legal system and the justice system is there to help bring justice, right? But I want you to take a deep breath with me. Okay, we're going to say this together. There is no justice in the justice system, right? It is very frustrating. I don't say that to discourage you. I say that to help save you a lot of money and time and energy. My job is to help you protect your peace and your sanity, right? So if we know that your high conflict ex, right, your abusive ex, they're not going to pay child support because they love money more than they love anything else, more than they love the child, right? And they're doing it as a means to punish you. We all know this. This is not a news flash. Does family court care about that when they're considering custody and things? No. Custody and child support are kept separate the majority of the time. Okay. Do not spend money to get money. Go through child support enforcement, social services in the area where you live, file an application for child support, allow them to help you. They can go after your ex, they can garnish wages, they will take them to court when they fall too far behind in arrears, and they're going to stay on their ass, not you. That is not your job. Do not ask them for money. Please do not put in your orders that there's going to be 50% shared expenses of extracurriculars and sports and co-payments and deductibles. Did your ex ever help you in the first place? No. So why are you going to waste your time putting this language in your orders? Don't do it. They're not going to help you. Can they garnish a self-employed person? They can't garnish them, but they can put them under orders that they have to make a payment. If they're not paying, right, they're going to lie about their assets. They're going to lie about their income. That's what they do. All right. But allow the state to stay on top of them, not you. In the meantime, I want to remind you that every single thing that has happened in your life up to now, you have resolved. Every single thing that has happened to you before getting to this moment, you have found a solution. You have found a way, right? I will never forget the days of I'm now remarried, right? But being a single mom of 4 children in 3 different schools, there was a time that they were in 4 different places, right? But I will never forget having to decide between getting something at the grocery store or having that money to put gas in my car because my ex wasn't paying child support. I've been married twice. I've been married to 2 abusers, okay? They were not paying child support, right? So I had to find a way. And I honestly, I don't know how. I got really creative with things and I figured it out. There was a part of me that for the longest time had to think, all right, you know what? Credit score, it's just a number. My credit score is, low at the time, right? It was really low when I had to leave my ex-husband. And so I'm like, all right, can I fix that right now? No. Is is life going to be okay? Yes, it's going to be okay, right? I was a broke single mom. You find a way. The system is not there to protect you. The system is not there to make everything better. And I'm not saying this to discourage you. Please don't be discouraged. You have to outsmart them. What happens when DSS never did anything and his arrears were over $30,000 behind and now it's just gone? The arrears never go away. And I know a lot of social workers, right? I studied human services at Purdue and I know a lot of social workers. So social worker told me this is the one debt that your ex can never outrun. It will always be there. It can go on their credit score, right? It can go on their credit history. It is never going away. I have 2 adult daughters now, 22 and 19, and my first ex-husband still has to pay me the arrears that accumulated when he was like MIA for I don't know how many years. He has to make an arrears payment every single month. And he's going to be paying that payment until he dies. Do they put liens on things? Not typically. And I wouldn't waste your time with an attorney and paying attorney's fees to get that to happen. These really tricky situations in family court. The numbers say this: mothers' claims of abuse, especially child physical or sexual abuse, increase their risk of losing custody. And fathers' cross claims of alienation virtually double that risk. So what happens? What does this mean? We have protective mothers, which most of all of my clients are mothers. Protective mothers are bringing forward claims of child abuse, child neglect, sexual abuse. They immediately have a target on their back. What happens then? Fathers create this narrative of how you're coaching the child, you're alienating the child from them, and that then plays into a protective mother losing custody. DARVO was implemented. The study further goes on and it talks about how the courts believed mothers' claims of intimate partner abuse only 42.6% of the time. But wait, believed mothers' claims of sexual abuse only occurs 19.4% of the time. So if intimate partner violence and abuse is only believed 42.6% of the time when it comes from women, when a mother brings forward claims of child sexual abuse, the percentage in which they're being believed decreases. Family courts only believed mothers' child abuse allegations less than 1/3 of the time. They believed only 1 in 49 cases of child sexual abuse when the accused father cross-claimed that the mother was alienating. Now, if you've been listening to me for a while, you know that I do not like the word parental alienation. It's junk science. It comes from Dr. Richard Gardner, who is not reputable, and it's not something that exists in the DSM-5, but it is used by perpetrators. What it truly is it's domestic violence by proxy, coercive control. Research has revealed that 50 to 73% of cases of child sexual abuse are valid. Yet, Mayer's research showed us that only 1 out of 50 cases of child sexual abuse was believed in the United States. And this happened in family courts between 2005 and 2014. You can get this information and fact check. I encourage you to do so about anything that I say. You can go to End Coercive Control USA. Women who allege abuse, particularly child abuse, by a father are at a significant risk of losing custody to the alleged abuser. Even when courts find that fathers have abused children or the mother, they're still awarding those fathers custody 13% of the time. I'm going to pause here for a second and let that soak in. Do you understand now why I caution you all on using the words child abuse, abuse? He was abusive. We can talk about patterns of behavior, behaviors by the high conflict parent, and let that be interpreted for the behavior itself versus us labeling it as abuse, diagnosing it as abusive behavior. I would much rather keep you and your child safe than not. So everything I just shared with you, you heard it correctly. Even when a court finds abuse has happened, they still give the abusive parent, and this is, again, fathers, custody 13% of the time. Right? So what is going on? We know that it's DARVO, deny, attack, reverse, victim, offender. It is the weapon that is used against you. It's important that you recognize DARVO. What changed after 30 days? So the first result was my high conflict ex's tone changed, right? He escalated in weeks 1 and 2 and then began de-escalating by week 3. There's a lot of data surrounding this. We do see an ongoing de-escalation of the conflict the more you use BIF. So this is the pattern, right? High conflict people ramp up first when you stop reacting, then they pull back. It is very predictable. Not every co-parent will shift. Not every co-parent will be on the same timeline, but yours can no longer weaponize what you never gave them, right? I'm not saying that BIF fixes your co-parent. I'm saying that BIF removes your contributing to the conflict. And that changes the dynamic, whether they like it or not. The second result was my stress dropped significantly. My shorter messages were equated to less time living in the conflict. I was not spending my days and my evenings crafting the perfect defensive response anymore and, anxious all day long, wondering what he was going to respond with next and when I needed to immediately respond. I was able to reclaim mental space and peace for myself that I did not even realize that I had given up. This part, I think, was what surprised me the most because I thought that Biff would feel like suppressing myself. Instead, it felt like freedom to me. I gave him less and I started to get my life back as a result. The third result was my documentation again got better, right? So Biff messages are clean and factual, and it's exactly what judges want to see, right? So I was cleaning up my communication over time because I was building my case so that I could file for contempt and modification. His escalating responses next to my, cool, calm, and collected ones, well, that was a contrast that was telling the whole story that needed to be told. My communication became one of the strongest parts of my case. When a judge looks at 6 months of communication records and sees that your messages are professional and that his are not, you don't have to really say a word, right? The evidence will speak for you. Now, what Biff does not do, because I've got to keep it real for you here, Biff does not stop a high conflict person from filing false motions or lying in court. Biff does not replace legal strategy. It is a communication tool. It is not a legal defense. And Biff does not work overnight. It's not a miracle cure. You're going to expect escalation before the de-escalation comes. Biff is not silence. It is not the gray rock method. It is not the yellow rock method. Please do not use these methods. I started doing it and it did not help, right? You are still communicating. You're just being strategical. I want to be completely honest with you. Biff is, not this magic wand. It did not make my co-parent a reasonable person. But what it did do was make me more unbeatable in my communication record. And family court, these things are really important. I was able to solidify my case with my communication. If I could go back to the beginning of my custody journey and give myself one tool, it would be Biff, right? Not because it is easy, but it's effective. And it turns your communication into evidence, documentation for your case. It removes the power of someone who has spent years using your own words against you. The seventh mistake that I see, violating the court order. Even if it's a small violation, I don't want to hear that he did it too. And, that's not fair. I know, I get it, right? But why does this happen? Well, there might be a part of your order that seems unreasonable or the situation might feel urgent, right? Your ex is not responding. You need to make a decision. So therefore you went and made it. This hurts you because one violation can cost you your credibility with the judge or even worse. And your ex and their attorney are going to have a field day with your violation. Even if he's got 20 violations of the custody order, that one thing that you did to violate the order is going to be used against you. Instead, you need to follow the order. To save yourself from this, you follow the order as written. If something in your order needs to change, then you file a motion to modify through the proper legal channels, but you are not going to sway from the order. You're following it. You don't want to give your ex any kind of ammunition. Follow the order, and then you can fight to implement changes when appropriate. Are you tracking their violations, right? Track their violations. This is part of your documentation for at least 6 months before you decide to make a move in family court. The eighth mistake that I see is assuming that your attorney will handle everything. Now, we touched on this a little bit before, right? Why does this happen? Well, you hired the attorney and you think that is their job. Not accurate. Your attorney is a litigator. Their job is not to really build your case for you. This hurts you because attorneys are not with you daily. They don't see everything that you're seeing. They don't know everything that you know, and you know your case better than anyone else, better than me, better than an attorney. And so it is up to you to give them your evidence and your documentation and build the case that is on a silver platter that makes their job easier. If not, you're going to be spending hundreds of thousands of dollars for a family law attorney when you could have been saving money by doing some of these things on your own. Instead, It's important, right? You've got to become like the CEO of your own case and family court, staying involved, organized, informed. This is all really important. Mistake number 9, underestimating the impact of DARVO. Why do I see this happening? Well, largely because people don't know what DARVO is yet. They learn about DARVO after it's already happened. Why this hurts us? Well, your abuser denies, attacks, reverse victim and offender rule. And it works on untrained professionals. Many of them are untrained. They don't understand coercive control. They don't understand domestic violence the way that I do, the way that you're learning to identify. I think it's really important instead that we name it for what it is, we document what's happening, and you educate your attorney on coercive control dynamics, right? Presenting just the evidence overall in your cases, you should be utilizing that same type of formula. All right, I'm using the formula, I'm listing the things out. I've talked about the different violations of our custody order and how it was a willful refusal. Dad willfully refused to return the children to me 100 times in the past 7 months. Wow. Okay, that's a significant amount of times. You guys have heard me talk about it before. Why do I use the number? Because the number is significant and it stands out, right? If dad had custodial time or the other parent had custodial time, parenting time, and they had in the past 6 months, I don't know, 50 overnights, let's say, and they didn't utilize all of them, they were unavailable or whatever, they only utilized 30 of those overnights, I would state that, right? Of the 50 parenting days that the other parent had, they only exercised 30. How did that impact the child? Well, we had to change our schedule. We had to rearrange our plans. We're feeling rejected. They were feeling sad. They were feeling abandoned, whatever. Don't overcomplicate it. I'm going to pull up something that you all have written within the community because I find that it's helpful, or maybe I shared it. Cleaning up documentation, sticking to what is important. This has been an ongoing discussion in the collective. How do I clean up my evidence? What is important? Since, we're taking action to file something in 2026, my attorney and I. Should I incorporate stuff from like 2023? Well, my answer to you is always going to be this. When was the last date of your order? When was the last date that this order was signed and filed and implemented? You want to look at everything that's relevant that has happened since the date of the last order. Not before, but after. Why? Because we now have a new court order in place that is the law of the land and it's not being followed. So what happened before that to the court and in the court's mind doesn't matter. It's insignificant. If you wanted to bring judicial notice to something, let's say your ex you're trying to get a modification because they have a drinking problem. Well, you could bring judicial notice to the DWIs that they've had. Let's say they've had 3 in the past 2 years. That's significant, right? Your Honor, I would like to bring judicial notice to these cases, and you better have the damn file numbers available and mention them. They are significant as, this individual has been arrested on 3 different occasions for driving under the influence. That is an ongoing safety concern. I have mentioned it with the other parent, and I'm hoping that the court can help implement safeguards for the children moving forward so they can continue to have visitation. It sounds very different versus I don't want him to have the children ever because he's got a drinking problem. It's like I identify he's got a problem. Why am I not doing the other? Because the family court system is kind of like you in the relationship back in the day. You know how you believed your ex's lies and you gave him the benefit of the doubt? Right. They give the benefit of the doubt far too many times. Okay. So if you come across as, your ex is going to be charming and charismatic and all of the things and playing victim and oh, what was me, right? But if you come across as not being aggressive, but rather firm and assertive of hey, these problems have occurred. I have tried to problem solve them. We haven't gotten anywhere. So I'm hoping that there's additional remedies. Do you feel the difference when I present it that way versus Your Honor, he should never see these children again? There's a huge difference. You feel it. You feel it in here, right? You feel it in the pit of your stomach. Your words come out differently. Your tonality changes. Check your tone. Practice speaking in front of the mirror. Listen to yourself.